I think we are live now. So, hello and very good evening to everyone. I'm Sanjana and I welcome you all to today's session. This session is a part of our larger project on forced migration under TMYS review, March 2022, in collaboration with Global South Colloquium, University of Victoria. We are also currently calling for submissions of essays, poems, and stories under the theme of forced migration. To know more about the submission guidelines and the project architecture, please visit www.tellmeyourstory.biz. So the topic of today's discussion is anti-trafficking legislations, a review of intervention and prevention programs. And to share their views and opinions on this particular theme, we have with us today Dr. PM Nair, Mr. Kaushik Gupta, and Dr. Veerendra Mishra. Needless to say, they have years of experience and are other experts on this topic at hand. And I'm very privileged to be in the company of these three very esteemed panelists. So before we move on to engage with our speakers, I quickly want to introduce them to our audience here tonight. So Dr. PM Nair is an international expert on human trafficking issues. He has served as an IPS for 35 years in Bihar, CPI, CPRF, and NDRF. Working against human trafficking for the last 40 years, he is currently the advisor and expert resource faculty of National Resource Center of Human Trafficking, Raksha Shakti University, and also the chairperson of the Center of Excellence and Center of Research and Learning on Human Trafficking of the Indian Police Foundation. I'm sorry, sir, this is a very brief introduction. There's a lot to say about you as well, but we just... And welcome to you, sir. And moving on, we have Dr. Veerendra Mishra. He was awarded the prestigious Hubert Humphrey Fellowship under Fulbright Scholarship on the subject of human trafficking at the University of Minnesota, USA. He has held various capacities in different ministries and departments in the government of India. His recent publications include a research study on missing children and linkages with human trafficking with BPRND, Combating Human Trafficking, Gaps in Policy and Law, under Sage Publications 2015, Human Trafficking Stakeholders' Perspectives, and several others. For Mr. Kaushik Gupta, he's an advocate practicing before the High Court at Calcutta for the last 22 years in the field of criminal, matrimonial, and human rights law. He has been active since 2003 in providing legal support to the members of the LGBTQ+ community for ensuring protection of their rights relating to their gender markets and sexual orientation. He has been heading a team of lawyers from West Bengal and Maharashtra and fighting the menace of human trafficking for the last 8 years. Thank you all. And I'm Sanjana Banerjee, currently in the final year of Masters in English Literature from Jadavpur University. And I'm deeply interested in the field of migration, and I'm a project assistant for TMYS Review March 2022. So that's all with the introduction. So without any more delay, I would like to get the session started. I would first like to call upon Dr. PM Nair to share his insights regarding today's topic of discussion. Over to you, sir.
Thank you. Namaste to all of you. Grateful to Madam Sanjana. And it's such an honor to share the dais with two eminent luminaries in this field, Dr. Mishra and Mr. Kaushik Gupta, whom I adore and admire for so many things in life. They have also transformed the lives of so many human beings across the country and outside. It's a great honor. Well, the topic is anti-trafficking legislations, a review of intervention and prevention program. When you speak of the anti-trafficking legislations, am I audible?
Yes, sir.
Yeah, anti-trafficking legislations. We have a legislation, very robust legislation in the country today. The Immoral Traffic Prevention Act, which deals with sex trafficking. We have a special legislations on labor, Bonded Labor Abolition Act and Child Labor Act and things like that. And in 2013, they brought in a definition of trafficking in the Indian Penal Code, a substantive offense, 370 IPC and 370A. Having said that, when you talk about the legislation part, one part we should remember is in this entire scenario, the need for new legislation was felt in 2016. A new bill was introduced in the parliament in Lok Sabha. So it could not get cleared in the Rajya Sabha, or did not go to Rajya Sabha at all. So it fell through. And the present government is trying to bring in a new legislation. Now, if you ask me the gap in the existing legislation, the Immoral Traffic Prevention Act, ITPA, which was made in 1956, and then it went on to a revision in 2000, in 1978, and finally in 86. It is a very, very powerful legislation. Of course, it deals only with the sex trafficking. Now, when you say powerful legislation means what? It empowers the enforcers, the justice delivery agencies in many ways. It also respects the right of the person. There are five presumption clauses where the onus shifts on to the accused in that legislation. Therefore, it is victim friendly. Then special legislation, special sections are there for child rights, protecting child rights. And there is a section of law in that ITPA which it gives a security and safety to NGOs, to civil society. If they go and conduct a rescue somewhere, there cannot be a civil or a criminal case against them for doing the job. So a specific provision is made in the law itself. Then the executive magistrate has been given powers to go and look for places of exploitation and close down. And once it is done in a proper manner with application of mind and substantive method, evidence, even a Supreme Court cannot interfere in that order. That's very interesting legislation we have. So having said that, this powerful legislation, though it's very powerful in many ways, as I mentioned, one gap I find is that the issue of rehabilitation, post-rescue care and attention, if you can put in a comprehensive manner, it means so many things. Post-rescue care and attention means counseling, restoration, rehabilitation, reintegration, all this will come. Psychological, financial, emotional, everything. That is not a rights-based act. It's a welfare act. So when you have a policeman who is tasked to rescue a child, that is his mandate, and after rescue, there is no agency which is tasked with rehabilitation. So unless that comes into law, this welfare approach should be replaced by a rights-based approach. The rescued person shall have a right to be rehabilitated. So unless that comes into force, it cannot happen. Now, in the new bill which has come up, which is already in a discussion, and it may come up any day in the parliament. There are only small clearance required here and there. It's again a very broad base. I'm very happy that they have taken several points from the earlier bill which fell through, and also incorporate a few points which was not there in the earlier one, which have been suggested by various persons. Well, and in that context, one important point missing in the present bill, it's very good. It's very good. It gives powers to the agencies. It sets up a new investigative agency. It calls for special courts. It calls for victim rights orientation. It for protection of victims' rights, protection of witness rights, and all those stuff. Only the certain points which I had some reservation was that the Immoral Traffic Prevention Act, certain sections have been taken into this legislation. Therefore, that ITPA should be subsumed. It should be repealed. And then a new definition has been given. Therefore, IPC 370 also should not have in existence. I would suggest 370 IPC, 370A IPC, and Immoral Traffic Prevention Act should be completely subsumed into this new legislation. They should stand repealed, so that the enforcement official and the justice delivery official, the courts and the prosecutors and police officers and all concerned, will have only one simple legislation, one legislation. That should be the comprehensive legislation. Second part is the anti-human trafficking units which have come to stay. We set up the first anti-human trafficking unit in 2007 in the UN ODC project. I was privileged to do that. Nair ASUs were set up And today, all districts in India, 729 districts in India, have anti-human trafficking units. Now, when the government of India set up, and this has found a placement in the Supreme Court ruling in Bachpan Bachao Andolan, where the Supreme Court has noticed and observed, it's in the text of the law, that anti-human trafficking units are specialized investigative agencies, and therefore, any child who is missing and not traced for 3 months or above shall be investigated by the anti-human trafficking unit. Therefore, a legal authority has also come in. Having said that, this anti-human trafficking unit is not mentioned anywhere in the legislation. That is very important, to have a legislation where the existing scenarios and structures should be taken care of. I can go on suggesting so many other challenges there, but I would stop here. The long and short of what I'm trying to say is the present legislation is good in so many respects, but it also, I wish it was more incorporating, more inclusive, and and make it one legislation where everything can be addressed. Then they are called something called the committees. Committees won't function. District level committee, state level committee. It should be authority. A committee is only a recommending body. So when you have a one-step approach in the district, all agencies in the district should be brought together in one umbrella, and that should be a district authority for rehabilitation. Well, these suggestions have gone to them. I don't know whether they have considered or not, but there are many important, practical suggestions have reached them, and I'm sure government of India may be considering all of them. Well, from that perspective, the anti-trafficking legislation today, unless this legislation comes up, we cannot say how good or bad it is. I'm sure the government is aware of all the suggestions and requirements, so they must be taking it forward.
Thank you, sir. Thank you so much. That was quite informative, and it was very interesting to note that particular point that anti-human trafficking units and all these discrepancies between how these they are only recommending institutes and how they should be incorporated within the law, and that was very informative. Thank you so much. Moving on, I would like to invite Dr. Veerendra Mishra to share his thoughts on this topic at hand. Over to you, sir.
Yeah, thank you so much. And PMNAS sir and Gupta ji. So I'm meeting him for the first time, unfortunately, though he's a stalwart in his own field. And PMNAS sir has been my mentor, so certainly, I always owe a lot to him. It's so great to share this space with them. When we talk about the legislations, one thing which he pointed out, and I think most of the people would agree to, is that having too many legislations or too many definitions would always be confusing. As I said, 370 is there, and when we are coming out with the new legislation, certainly it should have been revoked, or it should be revoked. I can't say it should have been, because it is still at the bill level. It has not been passed, so you never know what is going to happen finally. So that is one thing, because we shouldn't have definitions at two places. That is very confusing, and particularly for law enforcement, even if there is one word missing, then it becomes very confusing for the implementers, law enforcement. So this is one thing. Regarding the legislations, what globally we perceive is that human trafficking is the problem of the criminal justice. That is the biggest problem, and this perception is globally prevalent. It is not just in India, but everywhere. But actually, the criminal justice system has a very small role to play. If you go through the whole thing, if you go through the processes of trafficking, we see right from the place of origin to the destination point. What basically is the reason for a person getting trafficked? It is the vulnerability, and what causes vulnerability, that we have to understand, because here we are talking about prevention. So when we are talking about the prevention, the idea should be to somehow address the problem of vulnerability, and the vulnerability can be reduced only if the social justice system becomes very powerful, very active, proactive, and they start working on that. You can't expect criminal justice system to come forward and reduce the vulnerability. So that is one thing, because when we talk about the vulnerability, the causes of vulnerability, it includes many social, political, cultural issues, not many other things where the criminal justice system does not have much role to play. So that is why in legislations we should try to focus on that as well. So, the 4 P's that we talk about in trafficking, that is prosecution, prevention, protection, and fourth is the participation. So, all the other 3 P's become irrelevant if the participation is not good enough. And if that participation of all the stakeholders is not incorporated in the legislation, then doesn't work. It is very difficult, because then you have space to decide if you would like to invite them or not. If it is part of a legislation, then certainly, it would become a mandate for the system to incorporate that and to engage them. So that is very important. So participation is one thing, should be very much be part of the legislation, or otherwise, we have to create more space for them. So as we have been talking about, more focus or our approach has been more reactive. It's a reactive action that we bank on. You will see that, you will see that talking about rescue, their rehabilitation, their integration, how they are put in the shelter homes or some other places. This is what normally we talk about. So more focus is on reactive action rather than proactive action. So that proactive action is very important, because once a person is, trafficked, then 2 things play. If it is sex trafficking, there is stigma, and stigma is so strong that nobody can come out of it. The rehabilitation is completely a failure, and this has happened. There have been cases where there is a court there in Mumbai. So, and while I was talking to one of the judges who was there earlier, she used to talk about the same victim coming time and again being rescued. And when they asked, they said, we can't get reintegrated because the cause of the vulnerability at the place from where they are recruited, as they call it in trafficking definition, the point of origin. So if that is not addressed, the person is vulnerable again. So they because of the stigma, and so they move on. So they prefer to move out, or otherwise they are re-victimized. One is the stigma, and the second is the trauma. In reaction, we don't consider that part, the trauma part of the victim. So that is why proactive is more important, because we have to save them from the trauma also, because we lose a person once, we talk about reactive action. It is necessary, of course. If a person has been trafficked, they need to be rescued, they have to be brought back, they have to be rehabilitated in a proper situation. So those things have to be developed, but more focus should be on preventive and proactive prevention. There are 2 types of prevention that we talk about. One is proactive prevention, the other is reactive prevention. Reactive prevention is that once a person has been rescued, reintegrated, or rehabilitated, then we ensuring that they do not get re-victimized. That is reactive prevention. But proactive prevention is ensuring that they do not, they never fall into the trap of a trafficker. Trafficker is moving around. He's seeing who is vulnerable. So, these things are very important. So when we come out with the legislation, it should be very clear. What are we doing for proactive prevention? What are we doing for reactive prevention? What is going to be the role of the social justice system? How to, empower them? I think after a lot of debate, I think the Women and Child Development Ministry agreed to come out with a bill. Otherwise, it was always presumed that it is the role of the MHA. It was not the role of the Women and Child Development. Because it was thought that, trafficking means it has to be MHA. There has been a paradigm shift in that, but certainly in the legislation, it should be very clearly mentioned about all these things. Otherwise, we won't be, successful. The legislations won't serve the purpose that we are talking about. And when we talk about what centric legislation should be, it should be a victim centric or it should be an offender centric. So there has to be a balance maintained. Victim is equally important, and offender centric also is very important. Victim centric is important because if the victim is not strong enough, if you don't ensure their safety and protection properly, then your prosecutions fall flat, because they won't come out. They are not confident enough. So that is why victim centric is also important. Right from the prevention, for prosecution, you have to focus on them. So that is important. But at the same time, we have to be offender centric also. And when we talk about offender centrics, and then we have to train our people in the legislation, it should be clear that you just don't investigate a case, start at the investigation at the destination point and finish it at destination. No. If it is offender centric, then you have to figure out, because it's an organized crime. There's no doubt about it. there is an organized crime, there has to be a chain. And even for victims, there is a chain of custody. So you have to unearth the whole thing, find out the thread, and then the investigation should be properly done so that the whole network of the offenders is exposed and is taken care of. There's few things like which needs to be somehow mentioned in the legislation about all these things would certainly help the implementers or executors of the act. Thank you.
Thank you so much, sir. Thank you so much. The fact about the proactive and the reactive legislation is very informative. Thank you. And moving on, I would like to invite Mr. Kaushik Gupta to share his thoughts on this topic.
Thank you. Thank you. And it's an honor and privilege to be in this esteemed panel with Dr. Nair and Dr. Mishra. And I would say that very little is left to say after what Dr. Nair and Dr. Mishra has said. I would just, as a lawyer, I would like to point out that in India, the statute has never been a problem. We have sufficient laws. The problem has been the implementation of it and the execution of it. And also the lack of accountability with regard to its execution. With regard to the anti-trafficking legislations, the only anti-trafficking law that was there till 2013 was, as Dr. Nair said, ITPA or Immoral Traffic Prevention Act. Because interestingly, that with regard to the child labor or bonded labor, they do not talk much about the trafficking, the process of trafficking. The Bonded Labor Act starts from the point of bondage. In 2013, by the Criminal Law Amendment Act, 370 was incorporated, and we have a more or less composite definition of trafficking, which was lacking since independence till 2013. Now, this was a problem because until and unless you can define a crime, it remains vague and subject to misuse by the accused persons. The new legislation which has been proposed, and I must say that the bill that the government has shared with the public at large was prior to the suggestions that have been given. Post the suggestions that were given from the organizations working in this field with from other esteemed experts on this field, that has not come to my notice at least. So we do not know exactly what is the content of the bill that is to be placed before the parliament. However, I will presume that the suggestions have been incorporated or taken into account. And I would say that in the new bill, and I agree with Dr. Nair, that the earlier acts might become redundant in the event this new bill is passed. However, only thing that we see as of now is section 55 of the new bill, which says that if this new bill, the proposed legislation, is contrary to any other law, etc., then this new bill, which once it becomes act, will supersede those provisions. That is, this new bill will supersede section 370 as well as ITPA. But I also agree as a lawyer that if there are several laws on the same subject, then there is always a chance of misuse and misinterpretation. Therefore, this is something which the legislature needs to take into account. Also, I strongly agree with Dr. Mishra that the entire process, the entire approach of the state has been reactive. This is somewhere I feel that, let us say, if I may use the example of terrorism. In cases of terrorism, the government do not wait for the terrorists to attack. They do intelligence gathering. Human trafficking, as I understand, is also a form of terrorism. A terrorist might plant a bomb and take away lives. Here, a trafficker keeps me alive and takes my life away. Therefore, I feel from the perspective of human rights, the government should take a proactive stand and incorporate the process of intelligence gathering by which they can prevent the act and not merely pursue the punishment of the criminal once the offense has been committed. This is something which I feel is required to be looked into.
Thank you, sir. Thank you so much for your insight. And it's very interesting how you drew the parallel between terrorism and trafficking. It's so pertinent that we don't understand the gravity of this crime. So, until and unless you framed it like that, it was absolutely perceptive. Thank you. Moving on, we have arranged a brief question answer segment, and my first question is to Dr. Nair. And so basically, the question is, do you think there are any gaps? Okay, you've answered this, sorry. In your essay titled Prevention of Human Trafficking Dimensions and Strategies in the book Human Trafficking, the Stakeholders' Perspective, you have talked about the gaps in legislation in the case of re-trafficking. You also mentioned that while you were talking about saying your piece. So could you elaborate a little on the case of re-trafficking and these gaps which maintain the vulnerabilities of the victims of trafficking?
Yeah, thank you so much. And you speak about rape trafficking. It essentially means a person who is trafficked, exploited, rescued, and the person gets trafficked again. There are many reasons for that. Let me take one example of a missing child. Now, if a child welfare committee goes on record to say the same child appeared before that committee 3 times over in a matter of 2 months' time, rescued by the same NGO, what does it mean? It speaks volumes. Means we think the children are there commodities to be recycled and show numbers. I have rescued 27,000. I have rescued 47,000. That is very disturbing. Secondly, the right point which Dr. Mishra was talking about, reactive proactive approach, harm assessment. Unless you do an assessment of the victim's harm, Dr. Mr. Gupta, Kaushik Gupta rightly said about the terrorist perspective. The harm to the person is immeasurable. The traffic person is devastated, demolished. Now you get all the parameters to assess the harm to the person, and then compensate the person, then punish the person accordingly. That is not being done today. That harm assessment is not there. Therefore, the person is treated like another person, somebody else, and this actually enhances or exacerbates the vulnerability of the person, and the person gets becomes more vulnerable and likely to be trafficked. So the vulnerability of the person gets exacerbated more ways than one. Take the case of the people from a foreign country like Bangladesh. They used a system where the rescued person also was taken to the border and pushed back. The pushback system where you do for illegal immigrants, just reformed a bit, not too much, not to a full extent. The person rescued here is, of course, is not an illegal immigrant. It's a person trafficked, could be any age. But the trafficked person is brought to the border and pushed back, and the person is being re-trafficked. There are many dimensions which are not come to open, and therefore, even when there are islands of excellence in the entire response systems, that has not been replicated and institutionalized. Therefore, the problems still remain, and that leads to re-trafficking. When you say re-trafficking, the harm to the person, a re-trafficked person, is much more than what happened earlier. It again devastates the person. And now that person, to rehabilitate the person, it becomes further difficult. Therefore, there is a need for accountability, as Mr. Gupta rightly said, accountability to be brought in the system for proper means to be defined. Rights-based, the victim, the person-oriented paradigm to be brought in, where the accountability of the agencies has to be brought in under the law, and then the rehabilitation done, I'm sure that's the only way to prevent re-trafficking. Otherwise, it will continue for long like this. Thank you.
Okay, so there's another question for you, sir. There's an increase in corporate NGO partnerships to combat human rights violations, especially in the case of trafficking. Do you think of this as an effective prevention strategy? Could you shed some light on the gaps in the corporate partnership landscape, if there are
Good.
any?
You moved on to prevention now. Prevention is very important. In the legislation, my recommendation was that every section, prevention, prosecution, protection, all those, there are different sections in the law. I suggested each section should have a preamble. I don't know how many of you read that the commentary of ITPA by Justice Iyer, Krishna Iyer. It's a wonderful piece of a book. It's a classic literature, I would say. In that, he has also suggested the same thing, that there should be a preamble to every legislation. So I suggested that every section should have preamble. So what is prevention? Just by saying, oh, prevention, nobody will understand what is prevention. Prevention is source area, transit area, destination area, role of each agencies, accountability of agencies. What, even if it amounts to somebody can say those things have been important in the rules. Nobody cares the rules. So bring everything into legislation. The prevention should be a completely comprehensive chapter by itself. Then only it can take place. From that perspective, when you want to do prevention, you have to involve all the stakeholders. Under the Constitution of India, Article 23, human trafficking has been prohibited. So we, the people of India, gave to ourselves a constitution. In that constitution, we have written trafficking is prevented. Therefore, all of us are not stakeholders, but we are duty holders. So even the corporate is also a duty holder because of their constitutional definition. Therefore, the prevention matter has to be brought from that perspective. There, each one's role becomes very important. Corporate, everybody, teacher, student, professor, police officer, judge, everybody is a part of the system. They're all duty holders. Now, corporates have definitely been a very important source in many places. Many places, they can take the case of an entire rehabilitation package. They don't know how to do it. But if the civil society agencies can come in, law enforcement agencies can come in, the magistrates can come in, all together bring in a common platform, get the corporates also, and they can do commendable work. I can give an instance of 100 instances of corporate involvement in post-rescue care and detention and prevention. Jayanagar is a place in Madhubani district in Bihar. Lot of children were being trafficked from Jayanagar to Bhadoi in UP for carpet factory. When it kept on happening. You will rescue the children will go back. Somebody will come and traffic them, they will be taken back again. Finally, the corporates are told, boss, do one thing. You want children. Do one thing. Let the children study in Jayanagar. Open schools there. Let them study from morning till lunchtime. Of course, not COVID time, earlier times. Morning till lunchtime. Afternoon, train them on carpet making. Let the skills also learn. Even if it's a child of 10 years, 12 years, nothing wrong. Let them learn a skill. And 18 years time, the child is ready to be accepted in the job. The child will not be trafficked. No, that's exactly what is required. The corporate's involvement can make a tremendous impact, not only because they have the wherewithal, but they have the capacity to employ people. Lot of opportunities are there. Lot many opportunities. Naxalites, women Naxalites. I cannot officially declare that because it's a fact. Women, we brought them from the Naxal stronghold. We call them, brand them as Naxalites, but they're all trafficked. Many of them are trafficked. Brought them out from the stronghold, trained the security guards and carpenters and industrial stitching. Mind you, industrial stitching, the best so-called branded the things are being stitched by somewhere in the country. And in many places in the industrial stitching, we have brought these young women and men, trained them as industrial stitching, and they are doing a magnificent job. So today, the scope of rehabilitation is so good, so high, where the corporates can come in. They can not only fund, they can have the skill capacity, they can have the entire job opportunity, and they can provide a life with dignity, a sustained livelihood option with dignity. Therefore, the corporates have a very, very important role. Rather, they should step in because they are also duty holders under the Constitution. Thank you.
Okay, sir. Thank you so much. Thank you for these information. My next question is for Dr. Mishra, and Basically, the first chapter in your book, titled Combating Human Trafficking Gaps in Policy and Law, mentions the need to revisit the definition of human trafficking. Do you think that this revision of definition can in any way prove effective to law enforcement in relation to human trafficking?
Yes, certainly. I mean, to begin with an example. So when I was in US as a Humphrey Fellow, and I was having interaction with one of the police stations with police officers. So there was a case, so we discussed that, and I said, it seems to be a human trafficking case. So he said, no, it is not a case of human trafficking. I said, why? Why do you think it is not a case of human trafficking? So he said, first, straight away, it does not fix into the definition of human trafficking because definitions normally are very broad. So he said, doesn't fit into the definition of human trafficking. And second is they say that it's a modern day slavery. And where do you see this victim to be a slave? So his presumption was that slavery means the physical abuse should be there. There should be something like chained or something, I mean, that's how he looked into it. So, and besides that, in definition, this definition was given way back in 2000 in Palermo Protocol, which, which was picked by the Justice Verma Committee in 2013, which I always say that it was an unfortunate part because, we could have revisited that and, seen from the current perspective. Because in 2000, when the definition was given, so more or less it was presumed that the developing countries are point of origin where the victims are recruited, and the developed countries are the place where point of destination where the victims are exploited. It was a clear demarcation, and most of the in the definition it was again it was thought that or more focus was on cross-border trafficking. The domestic trafficking concept was not there much. And believe me, this I'm saying even after discussing with many people there in when I was a Humphrey Fellow. So I had a discussion, and they agreed to that. This is what it was. So in 2013, domestic trafficking had become a big problem. Every country is facing that problem. So the concept of traffic in the one of the main processes of transit transport, it is sometimes not applicable. If you take a case of brothel, where a victim's daughter is suppose she is exploited, then in that case there won't be any movement at all. So if you think that transfer transit is a component which has to be there in the definition, then it won't work. And thankfully, if you see the TIP report, which is still considered to be one of the major reports, so trafficking in persons report of which is released every year by U.S. government, Department of State, and which ranks the countries on the basis of the what you call it, the TVPA Act and the compliance of the TVPA Act. So if you see this, since a couple of years, I think they have started writing that transfer or transit is not mandatory. This one thing has been added. It has been incorporated there. So this is a big change. This wouldn't have been there. In the current legislation, the same thing, I think in the bill, this has been accepted and incorporated. So that is why when I've written about that revisit, this is one couple of things that we're talking about. And besides that, we generalize a lot when we talk about sex trafficking, forced labor, and organ transplant. Now we have started understanding, comprehending what trafficking is. When you see trafficking, there may be many more dimensions as well. So, just to give an example, there has been adoption trafficking. I remember when I used to talk about adoption trafficking earlier. So people used to say that okay, you can't do that. I mean, adoption is such a pious thing. Why do you add trafficking term to that? But now we have started accepting it. And in Western, I wrote that in 2015, and I saw just when I was doing some research, some of the European countries have added this illegal adoption in their law. So it has come sometimes in 2018 or something. In this bill also, this has been it was told to me that it is being added in the last part of the discussions I was there of this bill. So so adoption trafficking is missing. So if we don't have that in the definition, then people won't act on that. It would be looked from a different angle. IPC would be used or some other things would be used. if we, for abduction and kidnapping, already a section is there in IPC. But if it becomes trafficking, if you use the means of abduction and kidnapping for trafficking of a person for exploitation, then the sections are different. So these are like, more serious sections. So similarly for adoption, you can just can't go by this, the simple IPC cases. I mean, it has to be, if it is trafficking, it has to be trafficking. Similarly, I talk about like, medical trafficking. I coined a term called medical trafficking. It is not just organ transplant. Surrogacy was a big problem. And that is why international surrogacy was stopped in India. And at the same time, when I was there in 2012, I remember Russia stopped, even, not Russia, that was for adoption. Russia stopped adoption for USA. They didn't allow the USA citizens to adopt from Russia because there were some trafficking cases, which was brought into account. So, like, similarly, this portion is there, surrogacy. Similarly, clinical drug trials. If you see clinical drug trials, we don't talk about it. There was an investigation done here in Madhya Pradesh, where the subjects did not know that they were the subjects of clinical drug trial. So the fraud was there, and their life was exploited. So why don't we put them in the definition of human trafficking? So what we should do is we should try to see like what other type of crime can be brought into trafficking, and let us not do it. So when I was having a discussion with one of the policymakers, they said like, when we use the term slavery, so that covers everything, but actually it does not cover everything. If you generalize the term, so it does more harm than good. Because, if you give, and PM Nair is sitting here and he has been such a senior police officer and has been like, operational. So, ask him like, if you give a scope of interpretation of a law in the hands of a law enforcer, what will happen? It is either misuse or abuse. That should be limited. That should be restricted. So, that is why I said, we have to revisit the definition. We should see from the current perspective what needs to be added, what general terms has to be removed from there. And if at all the scope has to be given, then it should be properly defined. So that is what I meant by that. Revisiting definition.
Thank you, sir. Thank you so much. I think the next question might be an extension of the things that you mentioned, like you segregated between the different types of trafficking, adoption trafficking, medical trafficking, etc. So you had also talked about something like in that same book, you had brought up the hushed up topic of parent traffickers. So could you like shed some light on this issue, and if poverty is the only driving force behind parents forcing children into labor, can parents be really tagged as traffickers? Like, I just wanted to.
See, parent trafficking, again, because of our cultural background, we respect our parents. So in that case, it reflects in our legislation, in our action as well. So normally we don't, take any action against parents. But if there is a case like, which is very evident and which is blatantly, if the parents are trafficking their kids, and we can see that in many of the cases it happens. So in that case, particularly if you see children getting married, forced marriages at very young age, they have been sold for that. See, the system, I would say that the legislations provide safety net for children. Maybe there may be some limitations, but there are some safety nets. The Act says that, JJ Act says that if at all the parents are unable to take care of their kids, then as per they should be considered as child in need of parent protection. And there is a system where the state has to take care of that. Of course, as Mr. Gupta Kaushik ji was saying that, like, the problem is about the implementation and enforcement of the act, of whatever acts or the legislations that we come across. So, certainly, and sometimes I feel that perhaps, like, it is not only the problem of implementation, it is problem of the understanding of the laws as well. There is always, I call it as lack of conceptual literacy. Because people don't understand exactly. So we're carried away by our values. We are carried away many times with what we understand, and don't go through the law, don't understand the spirit and the letters of the law. So that is why such things happens. But of course, if a parent gets involved in trafficking of their kids, so we should make them accountable. They cannot just be scot-free just saying that they are parents. Otherwise, and poverty, as you said, if poverty is the only reason, sometimes it is not, and sometimes it is. But if poverty had been only the reason, then all the poor kids would have been trafficked, and all the poor parents would have trafficked their children. So it is not happening. So if it is not happening, then certainly, we have to understand that, the people who traffic, maybe there is sometimes avarice or greed, the reason for that. And, and many times, believe me, when we talk about trafficking of children from tribal areas, particularly if they are sent for domestic help, so the parents won't understand that their kids are being victimized or the kids are being trafficked. So sometimes they become a part of trafficking network because without actually knowing that they have become a part of trafficking. In that case, certainly we cannot blame them because they won't understand it. They think it is for the betterment of the kid. So here we have to see that how we educate them, how we spread the information, how we spread the awareness, and make them partner them. As I said about the participation, how do we participate with them and engage them in preventing trafficking? Thank you.
Thank you, sir. Thank you so much. Moving on, my next question is for Mr. Kaushik Gupta. There has been considerable debate over the Trafficking in Persons Prevention, Care and Rehabilitation Bill 2021. So what are some of the concerns that you think comes with this bill? Is this an effective change from the 2018 bill?
With regard to the debates that has been going around this bill, there have been a voice from the sex workers collective who have raised certain concerns. Now, what we need to understand is that this is a bill or this is a law which relates to trafficking. We need to, make a distinction between trafficking and voluntary sex work. Here, until and unless we can draw this difference, we will always intermingle and conflict the two, which is a problem. This bill only talks about forceful trafficking, which is a crime. And I don't think anyone will disagree with the fact that human trafficking is one of the worst form of crimes. With regard to this bill, the concerns that are there is that as we understand, as we know by now, and Dr. Nair and Dr. Mishra have spoken about it, that it's an organized crime. The investigation also needs to be in an organized manner. Now, in this bill, there are certain provisions from the 2018 bill, in the 2021 bill. I have seen that the definition of trafficking has been expanded. The applicability of law, which in the earlier bill was limited to India, excluding Jammu and Kashmir, now it not only encompasses entire India, but also takes into account inter-country crimes. In this particular bill, the definition of aggravated forms of trafficking has also been expanded, and many such aggravated crimes have been brought in here. There has been certain elaborations about the aspect of victim compensation, and I think this is a very, very important aspect, because as we all know that the conviction rate in cases of human trafficking in India is extremely low. At times, the system blames the victim for turning hostile, for not supporting the prosecution case. Now, what we need to understand is that if I am a victim of crime, until and unless the state provides me support, either in the form of financial compensation or medical help, including psychological counseling, I might not be in a position to support the prosecution. Until and unless a trauma assessment has been done, until and unless my PTSD is addressed, how can I be in a position to support the prosecution? And until and unless the victim is provided these supports by the state, the victim will also not be in a position to provide support to the state in ensuring prosecution of the traffickers. So this is something which is very important. It is also interesting that this bill says that the process of rehabilitation and the victim compensation will not be dependent on the criminal proceedings. And another interesting aspect which has been brought in is the involvement of the NIA, the National Investigating Authorities, which was not there earlier. These are certain things that has been brought in this act, which was not there earlier.
Thank you, sir. I think my next question is on the same bill. So another point that has triggered a lot of contention and debate is that the consent of the victim will be irrelevant and immaterial. So does this seem to be a concern? How could you shed some light on this clause and its consequences, per se?
Yes, this seems to be a concern. But I will say that this concern is not with regard to that the statement that the consent of the victim is irrelevant. Because we know that as long as the victim is in the place of exploitation, that victim's consent is no consent at all.
Okay.
Because that victim is not in a position to give a free consent. Secondly, that if a person is a victim of crime, how can that person consent to become a subject of a criminal offense? However, where is it a concern? It is a concern that the victim's consent, even an adult victim's consent, is not obtained when post-rescue the victim is put into a shelter home for years and is not allowed free movement. When immediately after rescue, a victim is placed before a magistrate for recording of 164, the victim is in a state of trauma, cannot give a free statement. There, though the statement is apparently supposed to be given consensually, that statement many a times do not include all the nuances of the crime that that person has suffered. If we talk about trafficking for commercial sexual exploitation, with sex being such a taboo in our country, most of the victims do not talk about the perpetual rape that has been committed upon them day in and day out. There, the consent of the victim has to be given importance. But as long as she remains a victim of the crime, or he or she is in the place of exploitation. Let us say in case of a labor trafficking, I am trafficked and I am in a bonded situation. I am seeing that many times that my exploiter is in hand in gloves with the authorities. So even if I'm asked whether I'm freely here, I might not have the courage to really raise my voice. Therefore, that is something we need to realize, that as long as the person is in the place of exploitation or is being a subject, a victim of the crime, that person's consent is not material. However, once I am removed from that place of exploitation, importance is required to be given to the consent of an adult Indian citizen.
Thank you, sir. Thank you for that incisive piece. So I think that is a very good point to take our discussion bring our discussion to an end. And thank you very much for taking out the time and joining the discussion tonight. Taking into account the global condition of human rights, I think it's extremely pertinent that we had this discussion today. We engaged in this topic. And thank you, dear panelists, and a very good night to you.
You have